outside is able to come in.
Item number 7.
Yes, 7.
Morning, guys. Morning, everyone. So we are in our public session. Thanks for joining us. We have the New Zealand Law Students Association joining us via Zoom to present our first submission this morning on the Correction Victim Protection Amendment Bill, Rema Narkle's Members Bill. We've got the member in charge with us in the room too. So, morning, Amy. Now, Amy, excuse me if I'm incorrect, but is G the way to pronounce your surname?
It's pronounced share. So if you say my last
Share.
name twice, shisha means thank you in Mandarin.
Okay, very good. So, Amy, Share, thank you for being with us. And we've got Annie and Annalise. And if there are any others that want to jump on board, they can come in as well. So we'll hand over. So, Amy, my name's James Meager. I'm the chair of the committee. Thank you for your written submission. Committee members have all read it, so you can take that as read. Please, in the next 10 minutes, just take us through the key things you want to draw to our attention, and hopefully leave some time for questions at the end. But over to you.
Yeah, just want to say thank you so much for inviting us to speak at the Select Committee today. My name is Amy, and I'm joined here by Annie and Annalise. We're representing the New Zealand Law Students Association, who oversees around 9,000 law students in New Zealand. And within our specific group, we have some people who write submissions to Parliament. And so now I'll hand over to Annie and Annalise to go through the substantives, and then hopefully for the last 5 minutes, we'll get into questions if you have any.
Thank you.
Kia ora. Thank you, Amy. So our position on this bill is that we support the bill as amendments ensure victims are better protected from their perpetrator, and it advocates for a victim-centred approach. The New Zealand Prisons Operation Manual outlines no contact conditions, which are referred to as NCCs for short. These are particularly involved for prisoners involved in family violence offences and other restraining orders. While the current guidelines provide a structured approach, the high threshold for obtaining NCCs may leave some victims vulnerable to unwanted communications. We support a bill to expand the authority to impose NCCs without court intervention. As a group, we propose a blanket ban on all forms of communication between prisoners and their victims. This could be done through a centralised system where victims' contact details are managed by a single point of contact at the prison, which would block all communication channels. This system should also include the contact details of family members, especially for those who are underage victims. In the UK, the North Yorkshire Police successfully implemented a similar framework, which ensured immediate blocking of communications from offenders to victims. We suggest incorporating exceptions similar to the Family Violence Act, which allows victims flexibility to suspend or reinstate NCCs and ensures compatibility with legal mandates such as emergencies and child custody arrangements. We support Section 12, which empowers prison managers to protect victims from unsolicited contact, particularly those with protection orders under the Family Violence Act. The corrections system, as it stands, aims to enhance public safety, uphold justice, and aid in the rehabilitation and reintegration of offenders. We support that the rights of both victims and offenders must be balanced fairly. We recommend clearer processes for prison managers to protect victims, including risk assessments based on the offender's history and developing safety plans for victims of serious offences. We also suggest amending Section 33 of the Corrections Act to allow prison managers to set specific communication conditions in consulting with victims regarding allowed contact. I'll now pass it over to Annie to finish speaking on our behalf. Thank you.
Thanks, Annalise. So currently there is no explicit power or function of the chief executive that focuses on the safety of victims, which they should be doing as per the purposes and the principles of the Corrections Act. The other means to protect victims from unwanted contact are only available to certain victims, for instance, protection orders for victims of family violence. A public protection order may still be an option, but the threshold is just realistically too high for most victims to meet, and it similarly does not focus on preventing victims from unwanted contact. Section 8 also has the potential to facilitate positive communication between correction staff and victims, and it is understandable that there may be some concerns that the rights of victims may subsume the rights of offenders, but there are multiple checks and balances in the Corrections Act to prevent this. Due to the significant amount of discretion of the chief executive, along with the language of the Act, there is enough flexibility to allow for offenders' rights to be considered. However, although we do support the amendment to Section 8, we do recommend that it provides more guidance for the chief executive to uphold their obligations. In particular, non-exhaustive examples of what processes should be put in place.
That concludes the summary of our submission. We'd be open to answer any questions if you have any.
Thank you, Amy, Annie, and Annalise.
Yes.
Members, questions?
Yeah, if you don't mind.
Rima Narkley.
Hi, ladies. I'm Rima Narkley. The bill is in my name. Look, thank you very much for your detailed submission. Very proud of you three, going into such detail and picking up on some concerns that that more seasoned people in the field have picked up on. So that's awesome. Hey, if I can just direct your attention to your paragraph 5.4 in your submission, where you reference the North Yorkshire Police in the United Kingdom successfully implementing a framework in collaboration with prisons. With your, and I haven't researched this, so this is a great point for me for research. With your research, did it include mail, handwritten mail, or was it just, if you recall? If not, that's okay. But can you recall if it encompassed mail as a form of contact as well? Because that's one of the issues that we've come across with cases in New Zealand, that people have been contacted by mail too often.
I can answer this one. So there was actually, we did have another student who was helping us write our amendment bill submission. So she actually did that on her behalf. So I'm not 100% sure if that did include mail in
Okay.
that. Yeah.
That's all right. We can I can look it up. Thank you. Second question, if I may, please, Mr. Chair. If I direct your attention to your 5.5 paragraph 5.5, under exceptions to the proposed scheme, you suggested allowing victims to suspend or reinstate non-contact conditions an unlimited number of times. And I really appreciate the thought you've put in this. The only feedback I'd have with respect to this is there's a problem, there's often a problem with coercion with our victims. And that's the only maybe concern I'd have with your suggestion, that if it's a victim that's susceptible to being coerced, then she or he could be coerced by others to suspend these conditions. But thank you very much. I'll pass it over to anyone else. But you guys are awesome. Thank you.
Thank you, Rima. Any other members have any questions for the NZ Law Students Association? No, very good. Thank you. Thank you for your submission. Very well put. What normally happens is when members don't have questions, it's that you've pretty much answered them all in the submission. So we do appreciate the time for you having provided the written submission and all the work you've done on it as well. I thought it was exceptional and really appreciated having the opportunity to work through it. So thank you all for joining us, and hopefully you are keen to submit on some more justice bills that we have in the future.
Yeah, can I just address Rima's point quickly before
Absolutely.
we go? So in our, I guess, our submission, we also talked about doing a risk assessment. And so one of the things that we were thinking could encompass that is having more victim-centered approach, where obviously resources might be an issue, but we're just assuming that resources won't be, where the victim, the staff will assess whether this victim might go under coercion or not. And that might detail whether, a victim can have these reinstatements of non-contact conditions. So that's how we would get around that issue.
Risk assessment.
That's very helpful. Thank you.
That is.
Thank you, Amy.
Thank you.
We once again appreciate your time and for being with us. Thank you. Members, we will move to our next submission in person from Abi Burden and Rhylee, who I'll invite you both to come up to the table and join us today.
That actually was us.
Yeah.
Hello.
Hello, good morning. Thank you both for joining us. Who is who?
I'm Rhylee. I'm Abby.
Abi and Rhylee. I thank you both for joining us. Now, Abi, you've given us a written submission that we've read, so you can take that as having been read. Thank you for providing that. If you want to, I guess, take us through the submission, the key points you'd like us to understand about it, and then perhaps leave some time for questions as you've seen before. But otherwise, you've got 10 minutes. Both of you have 10 minutes with us this morning, so we'll leave the time in your hands.
Thank you. We've got it prepared. Yeah, we've got a little
Absolutely.
speech for you.
You can go for it.
Good morning. We are students studying at Paraparaumu College. We were inspired to talk to you today about the Spill Amendment after being given a social studies assessment centred around rights and responsibilities. In researching the Spill Amendment and its points and struggles, we realised that we have quite passionate opinions and therefore responsibility. Responsibility to share our thoughts, especially when our words and actions could have a positive impact on others. And what setting has a greater responsibility to honour our rights than our government? The intricate relationship between a crime and its victim is very difficult to safeguard in writing and legislation. Our point today is that despite these challenges, you as the Justice Committee have the responsibility to still protect the rights of these people. In our written submission, Rhylee and I talked about how important this bill is for victims in Aotearoa. Our comprehension of the physical, mental and emotional pain which victims of crime are put through centred our message. We personally stand by all comments and encouragement made. Even afterwards, we still continue to research the bill and its potential issues. As we've been given this opportunity to speak, we would like to highlight the statement we made in our written submission about the difference between giving responsibility to individuals working in the Department of Corrections and ensuring they carry out this new responsibility with conviction and in the manner directed by the Bill Amendment and Justice Committee.
Upon further research of the perspectives on this bill, we have come to understand that many have concerns about the logistics of the bill and how they may impact its effectiveness. We agree with many of these concerns. We also understand that the bill benefits from being in an early stage where it can be refined to carry out the services it intends to perform as seamlessly as possible without legal and logistical conflict. However, ultimately we have faith in the true intention of this bill amendment. We believe it is worth working to resolve any issues and improve the bill in order to grant the full protections to those impacted. To gain some other opinions, we spoke with the counsellors and facilitators at Kapiti Living Without Violence, a local organisation working to prevent and protect victims of domestic violence. They agreed almost unanimously that this bill was an excellent and necessary step in victim protection. They said they have worked with victims who have protection orders, who have received unwanted calls from the respondent of the protection order while they are in prison, and have had to contact corrections to ensure this does not happen. This highlights the need for the bill amendment and shows encouragement from those with a strong connection. However, they also shared some concerns about the efficacy of the bill, noting there is sometimes a lack of communication between the Family Court or Ministry of Justice in general and corrections. This may mean that corrections is not always aware that a client is also the respondent of a protection order. This is a problem that should be addressed, not just for the purpose of this bill. However, we are hopeful that this amendment to the Corrections Act will lead to a greater communication between these agencies, which may in turn lead to safer outcomes for victims of violent offences and family violence.
In simple words, our advice and submission to the Justice Committee on behalf of the youth in this country is that this bill amendment still matters, and we think it could do even more than it was initially intended to. This bill amendment has exposed a part of our justice system where the victims of crime are left behind, where we fall short of protecting those to whom we have a responsibility, because their rights are a responsibility, and we must start by doing this small thing to protect them.
Thank you.
All good. Thank you both. That was an excellent presentation, and I think you should consider running workshops for submitters on how to provide a written submission and then talk to the key points in an oral submission. I thought it was excellent. Well done. Members, any questions for Abi and Rhylee?
Yeah.
Yeah.
Thank you so much for your submission. I was just wondering, as a part of your studies, did you explore any other areas that we should probably have a look at in terms of protecting victims in Aotearoa? And are there any other kind of key areas that you might like to see us explore?
Yeah, we really focused on this area. We tried to pick something small that we could really have an impact on. Definitely, there are holes, but I wouldn't know the specifics, and I'd definitely look into it.
And with like the communication between these two, like the Ministry of Justice, you were saying,
Yeah.
and corrections.
That was something that was brought up a lot by, so we talked to people at local organisations, Women's Refuge, and places like that, and that was kind of something they all brought up. Just in like their work, it was something they found difficult. So
That's really helpful. Thank you.
If I may, I'm Rima, and I'm fortunate enough that the bill's in my name. And thank you for coming out here. Thank you for the research that you've put into it, and thank you for realising it's an area of concern, and the passion that you've researched this subject matter with. I would like to comment on maybe a couple of things. I really appreciate how you suggested that one of the potential issues is that given responsibility as opposed to acting on that responsibility. So the way I feel is that by specifying this in the act, making, doing a zoom into this, adding it in and zooming into this, it will mean that we're sending the message that this needs to be acted upon. This type of protection needs to be afforded. So thank you. I'd also like to thank you for mentioning Kapiti living without violence and the examples that you learned from the people that help out there with respect to victims that have been contacted unwantingly. I appreciate the concern about the lack of communication between the family court and corrections, and indeed other main government bodies as well. That's something that has come about clearly when discussing this bill, and I'm so impressed that you two have picked it up. My hope for us in New Zealand is going forward, we'll work on this now, but a big dream would be that we could put these implementations in place, these systems that are not going to be cheap, but are obviously necessary, so that communication can happen much more quicker. And I really appreciate as well what one of you just said. Your research has exposed a part of our justice system where victims have been left behind. That's really profound. So thank you very much. So appreciative of you two, and keep it up.
Thank you.
You guys, I had a question about so the process of you finding this bill and it being a part of your course or studies at school, how did that come about? Because it's for us, for me especially, you're the first secondary students I think we've had present before us, aside from the Ram Raids bill, I think. And we've had a limited number of submissions on this. So for you to pick this up and be something that's passionate about and you've found it somehow, can you explain to us how you went through that process so we can encourage more students your age to get involved?
yeah, so this is an assessment that we're doing actually, and part of that is a social action. And so we've got people in our class organising protests and fundraisers, and we knew that we wanted to engage with government. We went on a trip to Parliament, and this was something that they really encouraged, and I really took that to heart. And so when we're looking to do that, submissions are, I think, a really great way. It's a really great way to be able to talk to all of you. And we knew that this was an area that we felt passionate about. And so when we were looking for bills to submit on, this was one that came up quite quickly.
It was closing in like a couple of days. We went, no, we really, really like this one. So we wrote that really, really quickly.
That's very good.
I think that's a key point. You get something in, and then when you get to the select committee stage, you can expand and you can
Yeah.
fill
So
out
when
some
we
of the points.
submitted that, it was quite brief, but we spent a couple of weeks working on the points we really wanted to elaborate on.
Talking to people who knew a bit more than us.
Great, thank you. And just one final one, in terms of how you found the process of making a submission, coming to Parliament, engaging with the clerks team. Did you find that went well? Is there any suggestions for improvements for us? I'm just looking for ways that we can continue to encourage young people like yourselves. And
I thought it was really well. The way it's set up when you're putting your written submission is really easy. It's really explained. We had a lot of support from teachers and also from people in the this was really and people in the education department when we went into Parliament. So you guys are doing great.
Yeah, you do actually encourage it quite a lot. And every time I talk to someone about it, they went, "This is great. You guys are going to have such a good time." And so I think there is already quite
Such a great
good energy around
experience.
it already.
Oh, that's really great.
Well, thank you. Appreciate that.
We aim
kind
to
feedback
please.
for the class. And I'm sure it's
Group through.
getting very close to lunchtime, so there must be a lunchtime shout on for, what was your name? Sorry, Mrs. There'll be a lunchtime shout from your teachers there as well. But appreciate your time here this morning. Thank you for your submission, and thanks for being with
We
us.
appreciate it.
Thank you so much.
Thank you.
Right, final submission this morning will be in person, and we've got New Zealand Human Rights Commission with us again today, and we've got Philippa and Brittany joining us at the table.
Apologies for Philippa, you actually have Hannah and Brittany.
Oh, sorry.
That's fine. And apologies from Sonoma Lee, our acting chief commissioner, who has another appointment at the moment. And apologies that we might not be as fun.
Sorry.
Oh,
Yes, remind me, is it Helen?
Sorry, I'm Hannah.
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 And I'm Brittany.
Brittany, it's correct on this updated agenda.
Thank you both. Brittany, I think you've been before us quite recently, so you know how this process works. 10 minutes to just take us through the key points of your submission, anything you want to highlight to us, any changes you might see that needed to be made, any points to pull out. Just bring those to our attention, and hopefully some time for questions at the end, but I'll hand over to you.
Thank you, Mr. Chair. Tēnā koutou committee members. Very hard act to follow there, so we'll do our best. But yes, we're here from the Te Kahui Tika Tangata Human Rights Commission legal team. And an important part of the Commission's work is helping New Zealand meet its obligations under international human rights law. And so we've referred to some of those things that the committee might be interested in considering as part of our written submissions. But we're going to touch in a little bit more depth on a couple of those this morning, in particular the committee for the elimination of discrimination against women. And I do have a copy here to hand up if anyone wants to take that away today. So first up, the committee, the Commission supports the intention of the bill, and we're very grateful for the opportunity to make submissions on it and hopefully encourage some further action in this area, because as all the submitters this morning have acknowledged, it's a really important area. On the one hand, we can see, and I think it's been acknowledged while this bill has been in process, that there are already a lot of tools in the kitty to help protect victims from unwanted contact. So there's aspects of legislation, there's court orders that can be made, and there's also procedures in the prison operations manual. But as the previous submitters highlighted, we've also heard from our stakeholders that sometimes survivors of crime and violence do receive unwanted contact from people in prison. So there clearly is an issue here, and it's part of a wider issue in Aotearoa, New Zealand. I'm sure that everyone here is aware that New Zealand has some pretty woeful statistics when it comes to gender-based violence, violence against children, and that's often brought up when we're being scrutinised in the international human rights stage. So we're here really to just build on our written submission and encourage the committee and Parliament to consider more deeply what things can be done to address this, because often whilst legislation has a very good intention behind it, as this one does, it can be a bit of a blunt tool in the face of very complex, multifaceted issues. And again, now turning to the committee on the elimination of discrimination against women, or the CEDAW committee, it made a general comment in 2017 noting that legislation addressing gender-based violence against women can be inadequate or poorly implemented. So that's something to just bear in mind as legislators. We think that ultimately the most effective solutions to this very big scale problem lie in taking a human rights approach to wider scale systemic changes. So just to take sort of one example today, it's very important to have easy access to strong social support systems. That means things like safe, affordable housing, including emergency and social housing, livable benefit levels, food grants, access to comprehensive disability services, good primary health care, mental health support, as well as the more specialist family violence services. And experts working in family violence say that those things can help reduce family violence occurring, but also obviously help people get out of situations that they're in. This again is reflected in comments from the Committee on the Elimination of Discrimination Against Women, where they said that a woman's right to live free from gender-based violence is indivisible from and interdependent on other human rights, including rights to life, health, liberty, security of the person, equality and equal protection within the family, freedom from torture, cruel, inhumane, degrading treatment, freedom of expression, movement, participation, assembly and association. The committee also warned that significant reductions in public spending, often as part of so-called austerity measures following economic and financial crises, can further weaken states' responses to gender-based violence. And the committee recommended that states ensure that there is access to financial assistance for free or low-cost legal aid, medical, psychosocial and counselling services, education, housing, childcare and employment opportunities, both for survivors and also their family members. They also said that factors that heighten the risk to women, such as ready availability of firearms, need to be addressed by the state. I'd like to just talk now about some reports, and I think they're mainly referenced in our submissions, but there are some initiatives that have occurred quite recently, and a lot of mahi and goodwill from communities have gone into those. So we've got reports like Te Tangi o Te Manawa Nui, which is recommendations for reform from the Chief Victim Advisor. We've got Te Aorere Kura. We've got the family violence death reports from the Health Quality and Safety Commission. And of course, we've got the upcoming report to be released from the Royal Commission of Inquiry into Abuse and Care. So those reports had a lot of involvement from stakeholders, and so they've going to have very well-informed recommendations in them. And those are the things that can really help advance victim and community well-being, and that's very consistent with taking a human rights approach to solving issues. And that's also going to help us meet these international human rights obligations that we've been referring to today. And Hannah's going to go into those in a minute. We also just wanted to note one suggestion from the Law Society submission that we've read, that we need to make sure the wording of the bill is meeting its target so that it's workable and consistent with other legal obligations. So I think they've suggested looking at making sure there is a clear definition of victim and also of unwanted contact, so that you are targeting what you want and not things you don't want. And then finally, just in terms of implementation, it's very important that things are victim-centred. Previous submitters highlighted this as well. So the CEDAW committee noted in that general comment that all measures should be implemented with an approach centred around the victim or survivor, acknowledging them as rights holders and promoting the agency and autonomy. Thank you.
So as Brittany said, I'd like to draw the committee's attention to a few other pertinent comments and developments from the international human rights context, which touch on the issues that motivate this bill. That's part of our role as a national human rights institution or an NHRI, and everything an NHRI does is about improving outcome and impacts for human rights in the bigger context as well as particularly in relation to this bill. The Human Rights Commission is accredited with A status internationally under the Paris Principles, which means that we have speaking rights at the UN Human Rights Council and we're seen as valuable, trusted, and independent internationally. We've already referred to the CEDAW general comment, which discusses states' obligations in relation to, gender-based violence, including responsibilities for acts of non-state actors. And there are also recommendations from CEDAW about measures for victims. It's important to note that New Zealand will be reviewed in Geneva against the CEDAW Convention later this year. Our review is coming up and we can expect close examination of New Zealand's record on family violence this year. Special Rapporteur on Torture has also published a report, this one's in 2019, about the relevance of that prohibition on torture in the context of domestic violence. And in reviewing a country's compliance with the Convention Against Torture, that committee, the Committee Against Torture, and the Special Rapporteur on Torture always tend to routinely request information on the prevalence of violence against women in countries around the world. New Zealand was a proud early signatory of the Convention Against Torture, and in August last year, that committee reviewed New Zealand. The Committee Against Torture last year remains seriously concerned in its report about the high levels of violence and the disproportionate impact on groups such as women, tangata whenua, people with disabilities, and ethnic minority groups. That Committee Against Torture also commended the work that New Zealand's already doing to address family violence, and many states made those same commendations in the recent Universal Periodic Review of New Zealand's human rights record. That work that was being commended includes Te Aorere Kura, the establishment of the Minister for the Prevention of Family Violence and Sexual Violence, and Te Puna Nui. Sorry. As Brittany's already noted, there's a lot of work there that's human rights-based work that's has had international recognition and that is going to again have international scrutiny later this year. So while we really support the intention of the bill and we really hope it will be a springboard into more wide-scale improvements, taking a human rights-based approach to help improve New Zealand's human rights record in the area, we accept the bill intends to address a real issue and to address that narrow issue and the broader issue, much more is required, and a human rights-based approach requires the involvement of those most affected.
Thank you both. Members, in the sort of minute we've got left, any questions for Brittany and Hannah?
Maybe a mixture, somewhere between question and statement. Thank you, for your submissions. Do you need tissues?
Yeah.
There's tissues here.
Oh, thank you so much. Sorry.
Yeah. I noted, I noticed the overarching kind of message that you support the intention of the bill, but you'd like it to be an opportunity for us to go deeper into those more profound issues that are connected with the subject matter of this amendment bill. And I appreciate that. And that seems to be a message that's coming through with a lot of the discussions we're having about the bills coming through this very busy select committee. And I note the suggestions you made with respect to recommendations. So I've looked into those, and I'll look deeper into those as well going forward. Thank you very much. But no, thank you. I don't have any specific questions.
Thank you.
Very good. All right, thank you both. Appreciate your time. Now, we're about to move to a private session. Can I just acknowledge Tim Costley, MP, for all taking us to join the room. He's obviously gotten wind that his constituents are here presenting, and he's come to support. So thank you, Mr. Costley. And in saying that, we now have to move to a private session. So I would thank our public members for being with us and appreciate everyone's contributions today. So thank you both.
Thank you.
Thank you all.